So with regards to our next speaker, I remember when I first met him, I didn't think too much about it, to be honest. I then got to know him a little bit better by working with him. He was my chief at the Harris County Public Defender's Office, and he was chief of the Felony Trial Division. And I got to the point to where I worked with him very, very closely. Initially, I didn't think we were going to get along too well. But the more I worked with him, the more I saw a different side of him. A lot of people, you tell them your problems, they'll cry with you, they'll hug you. You tell Mark Hochglaube your problems, he's gonna try to figure out how to help you. Prime example, one day I called into work and I said, hey, my brake light just came on. I think I need to get this checked out. Mark didn't harass me about not coming to work. Instead, he said, Jackie, are you stranded somewhere? Do you need me to come get you? I can come get you. Didn't care where I was in all of the Houston metropolitan area, and I live in Fort Bend. He was willing to come to me. There was another instance where someone at work was having a child care issue. Mark's response was, well, I've got 3 children at my house and a nanny. I don't think adding one more is gonna make that big of a difference. So I got to see this very personable side of Mark. I also got to see him as a lawyer. And his way of thinking was very different from mine. It was very technical, very black and white. I'm more emotional, operate off of passion. So it was interesting to look at his stylistic differences and realize that I'm not Mark, but I can truly appreciate the way his mind thinks. It was his mind that thought about doing this particular seminar. This is his brainchild. He is board certified in criminal law, and I feel the need to tell y'all that because he came dressed in blue jeans today. But that was because I dared him to. So I am honored to present to you my former chief, my friend, my colleague, Mark Hochglaube.
Thanks. So I want to start, the topic is supposed to be trial preparation, which I guess I want to, it's a pretty vague term, and I want to start by sort of trying to explain what my objective is here for the next hour or so. And the best way I know to do that is to say what it's not. I've been to a lot of CLEs where, I mean, really great lawyers talk about all of their amazing preparations, and they give this list of 37,000 things that every lawyer has to do in every single case in order to avoid being disbarred. And what's up? I got to be close to the mic, is that it? Okay. So I don't want to do that. I always walk away from those CLEs feeling pretty sheepish about the quality of my own representation, and inevitably, you know, when I listen to typically it's really excellent lawyers who probably only handle a handful of cases at a time and have the time to spend weeks and weeks and weeks on any particular case. I ultimately come to the conclusion that that just doesn't really apply to my practice. So what I want to talk about is, and what I'm hoping to accomplish here, is just to give a few nuggets of tricks that have ultimately proven helpful to me. Maybe they prove helpful to you. Maybe you can modify them or adapt them to your own practices. Maybe not. If not, you got a free hour CLE. And to this idea, you know, I want to start with the idea, with just understanding that, you know, it's not possible if you maintain any sort of caseload to be trial ready on every single one of your cases. It's just not realistic. And my brain, it does not have room to be prepared for every single trial, for every single non-trial setting as if it was a trial setting. And I'd say this, I know I'm sort of speaking to the obvious, but there's a lot, I've heard these CLEs, you know, these attorneys that they make it sound like when they show up for pretrial motions, they're already ready for trial. They already understand everything that's going to happen in trial. They've got it all planned out. And I just, that just rings very hollow to me, and I think it's bullshit. And so what I want is to sort of talk about how to get from the typical state of readiness that you may be at in a pretrial motion setting or a disposition setting, how to go from there to actually being ready for a trial when that jury is in the hall. And I guess to start with, I want to sort of describe what I generally feel like is my status when I'm at a non-trial setting. I have a general understanding of the case. I typically have read the offense report. I have an idea of what the issues are. I have a general sense of who the important witnesses are, and hopefully I've gotten an investigator to at least start looking into it. And I certainly have conveyed whatever the plea offer may be to my client. But, you know, in terms of being ready for trial, I'm not. And so when I was at the public defender's office, sort of because we had a couple situations where attorneys were, I guess generously, I described them as being unprepared for trial. We started basically a system where every attorney that had a trial setting had to bring their file to another attorney to be reviewed, just to have another attorney's take on it, just to have another attorney look through that file. And we basically came up with a checklist of the things to look for, the things that reviewing attorney would go over, just to write a memo and tell the trial attorney, hey, you might think about this, you might do that. And most of the time, I think it was probably me that did the reviewing. I know Janie did a bunch of them, and Angela did some too. But with this checklist, I had a chance to review probably about 100 or so trial files. And it was really informative in a way just to have that sample size to look at. Because, you know, in my experience on my own, I didn't really realize how frequently the pleadings on cases are really at issue. You know, it's very, very surprising. I would say in about 30%, maybe a little more, there was a significant pleading issue in the case. And I would say in another 20%, there was something. There may not have been, you know, overwhelming, but there was something that was worth noting or worth, at least worth being aware of. And what I started to do was I started to look at the pleading really, really closely. And that's where I started. And with every trial file, I'd start with the pleading. And, you know, I think for a lot of people, they set a case for trial, and there's almost a paralysis that develops because there's so many different things to do all at once, and you don't even know where to start. And I would just tell you, starting with the pleading is a really good centering technique. Just to stop with all of the other noise out there, your clients shouting, the prosecutor and judge shouting, and all your worries about how on earth you're going to possibly get this case ready for trial by whenever. Just stop with all of that, pull out the pleading, pull out the penal code, and really break down what it is your client is charged with. And I look at the pleading, I say up there like 10 times, I really do read the pleading a lot. And I didn't do that before, but I do it now, and it really helps to just look at the statute, the penal code statute, look at Mac's annotations in the book, and just sort of rummage around with it for a good hour or so, and really think hard about what the pleading says. I also make sure that I understand what the punishment range is, of course, and that's easy. That's not as easy as it sounds, because almost always there's variances. There's enhancement paragraphs that may or may not be pled correctly, that may or may not be pled at all, and it's critical that you know what the punishment range could be, even if it's not written on the indictment. It's also critical that you understand, if there's some factual issue that it could make the case significantly more serious or much less serious, and it's just important to see all of those different angles. After I'm done with the pleading, I try to do basically the bullshit CYA. You make sure the request for notice of extraneous offenses is filed. I put down all of the different statutes, and every single one, even if it's not a child abuse case, I put this stupid child abuse statute in it. And the idea here is you just want to have yourself covered. And make sure that, that you've requested notice of experts. If there's a punishment election, I'm not saying you need to have filed it, but you should at least have thought about it. And I always file the court's discovery order. Even if now in the day of Michael Morton, it may not seem as important, but I don't know how many times the judge looking at their own signature on an order has made a difference in a trial, as opposed to, there being some other understanding of what the discovery was supposed to be, some informal agreement or even a written request that complies with Michael Morton. The standard discovery order is just more persuasive to the judge trying the case. And I just make sure that stuff is tied down. And once I've done that, I think to myself, what is the evidence, and if I could have a magical world where I could exclude anything I wanted to, what would I want to exclude? What is there out there that I can exclude? And again, it's not to say you're going to file the motion to suppress or the motion in limine. It's not to say that there's, you've got something solid to work with, but I just try to go through the sort of laundry list of things that could be used to keep evidence that I don't like out. And typically at this point is when I start to think about the idea of planting appellate issues. I can't encourage you enough to come up with something when you're going to trial that the judge is going to tell you no to. And to have that in your back pocket so that you can lose the motion to suppress, or you can have filed another motion that the judge is going to deny, but just to have that available to you. And I tell you, it's great for your client to have something meaningful on appeal. The appellate attorney coming behind you will be grateful that you did it, but also just for your own benefit. As a person that's written many appeals, I hate writing ineffective assistance to counsel. I hate claiming that. It's a loser of an issue almost every single time, and you just feel like an asshole for calling out some other lawyer for it, right? And if I have something else to write about as an appellate attorney, I will do it. If I have something to sink my teeth into, I will choose that issue as opposed to an ineffective assistance claim. Which is why, if you, as the trial attorney, make something preserved, just have something there in the record available for that appellate attorney, you will cover your own ass, and you will basically keep the spotlight off of you, and whatever ineffective claims the appellate attorney coming behind you might have. On the checklist, we go through whether there's mental health issues, if there's a sanity or competency issue, if there's some fundamental constitutional claim, which is not all that often, but it happens. Speedy trial, double jeopardy. And then I pull the jury charge. And I get this out of the district court's website, and I just have it. And I make sure that I'm clear on what the lessers are likely to be. I'm clear on whatever defensive issues. I have an idea of whether it's a result or a conduct-oriented offense, because it can make a difference in the jury charge and in the mens rea definitions. And whether there's going to be a parties charge, whether there's going to be an accomplice charge. I just want to have all that and sort of have noted whether that's there. I'm not saying that you need an investigator in every single case. I think in every single case where you've got civilian witnesses, you probably want to have an investigator talk to that witness. In a couple of the cases, I sort of intend to spend a little bit of time going through this checklist, and then I want to go through a couple case examples of how I took what I learned from the checklist and got prepared in these cases. And then you'll see in a couple of these cases, I didn't have an investigator. It just proved not to be necessary. But I think you certainly want it. You want it if you have a civilian out there that's going to give meaningful testimony in your case. You want to have an investigator at least try to talk to them. I think you got to do that. Make sure that you review all of the witness statements closely. Make sure that there's all the records out there that are available or subpoenaed, or you have access to them from the state's file, either way. And then